they have a better idea of what may be happening in the farming world, and we pass those rules. When it
All right, good afternoon, everyone. Welcome to the full Committee of Governmental Affairs. And we're going to talk a little bit about some bills that just happened in subcommittee and get the recommendation from Chairman Powell. Chairman Powell, let's start with House Bill 186 by Chairman Ron Stevens. Did the subcommittee take action on that bill?
Yes, sir, Mr. Chairman. There was a do pass recommendation and vote in favor of passage to full committee.
All right, great. Then for members of the committee, we're going to ask Chairman Stevens to present House Bill 186.
Thank you, Mr. Chairman. I see most of the
Is that mic on?
I'm here on the subcommittee. Thank you. Essentially, what House Bill 186 does, we had a large public hospital that was sold in Savannah. The bill is tightly drawn. It was purchased by a private hospital. And to cut to the chase, this bill allows the funds to be used outside of the hospital for health care for indigents and indigents only. As simply as you can put it, that's the crux of the bill.
Thank you so much. Questions from members of the committee on House Bill 186? At this time, I'll entertain a motion. Got a motion to pass? Tons of seconds. All right. Any discussion? All those in favor, please signify by saying aye. Aye. Those opposed, like sign. Ayes clearly have it. Congratulations.
Thank you, Mr. Chairman, members of the committee.
Chairman Powell, do you have a report on House Bill 24?
Yes, sir, Mr. Chairman. The bill with 2 amendments passed out of subcommittee to full committee.
All right, that is Representative Vernon Jones. Representative Jones here.
Thank you, Mr. Chair.
You were in agreement with the amendments that were offered earlier?
Absolutely. The chairman, distinguished chairman, and Representative Fleming helped perfect the bill, made it even better. So.
Okay. For members of the committee that weren't here for the sub, you're going to be working off a document because we couldn't pass or actually get a copy to you quick enough. So, do you have the changes that were made? If not, we have them here. Do you have them? Okay, Molly's got them. Then we'll get this to you so you can explain as is, and the changes that were made.
Mr. Chairman, I do want to make available to you, some of the committee members didn't have copies of the Supreme Court ruling on this one.
You know, I don't have the reach you do.
Sorry about that.
Thank you.
That's one of my challenges for buying clothes. Okay, Mr. Chairman, this is more of a housekeeping issue. It deals with the result of a Supreme Court ruling about who can make appointments, and it goes to the heart of private organizations versus public officials. And because public officials are held accountable to the people, our Constitution does not provide for private organizations to make appointments. And there were, again, 2 rulings. First was Mag versus Rogers in 1979, and then it was backed up by unanimous consent this past 2018. The opinion was written by the majority, or written by the Chief Justice, Harold Melton, and it just simply says that private organizations can't be making these appointments. However, I support if they want to do that, but the Constitution has to change. And a case point was dealing with the JQC, the Judicial Qualification Commission, when Representative Willard passed a Constitution amendment because the state bar was in the Constitution, and the state bar was removed from making those appointments. They can make recommendations, but can't make the appointments. And so it's simple, and Representative Fleming and Chairman Powell was helpful in clarifying it for an organization or individuals who may be confused by this, or maybe not certain, or have some concerns, and I accept those wholeheartedly.
Okay, for the benefit of members, if you would, the line that the amendment was made. Would you be kind enough to, do we have a copy of that model?
I can read, want me to read
Yes,
this, Chair?
please.
Okay. Starting with line 12, it says, all members of state and local boards, authorities, commissions, and similar entities in this state shall be appointed or elected by an elected officials, by an elected official or officials of the state, or by an elected official or officials of political subdivisions of the state. I know I was kind of,
Kind of butchered it here.
well, it was kind of,
Yeah, you
I
did
ain't gonna say
her
it's kind of
writing.
butchered
I
on
get it, I
here.
get it.
I'm blaming him. I can read it again. I think I got a little more.
All right, go ahead.
Okay. So all members of the state and local boards, authorities, commissions, and similar entities in this state shall be appointed or elected by an elected official or officials of the state, or by an elected official or officials of a political subdivision of the state.
All right, very good. All right, at this time, we'll take any questions of the bill. I think that we were trying to clean up an issue that we had a ruling on. Representative Mary Margaret Oliver, please.
Committee, I told the chairman that I was going to have to miss it for appropriations, but this comes out of, I'm not sure how many entities were created with nominations coming from private entities in the area of ethics commissions. I wanted to ask, and you probably got this answered in your subcommittee, how many existing commissions does this impact now that the amendment is added? Do we know that?
Chairman Powell.
I don't think that we know that, but I think that the Supreme Court case that was cited to us was very clear. It did not limit the decision of the Supreme Court to an ethics commission. It basically said an elected body is prohibited by the Constitution from delegating their authority to unelected people. That was contrary to the Constitution, and as a result, I think that Representative Jones is probably correct that we need to make it clear in state law that you just can't do this. Otherwise, there's going to be continuing litigation about it.
Chairman Powell, if you will, we're going to ask Legislative Council, do you agree with that interpretation by Chairman Powell?
Yes, sir, I agree with that. The Supreme Court just said you can't delegate.
Thank you. Representative Oliver.
I agree also, you can't delegate. But what is I was trying to figure out, I understand your amendment. Is the purpose of your amendment to, if I interpret it correctly, please correct me if I'm wrong, that the State Bar of Georgia can nominate somebody to be on an ethics commission, but the commission has to vote on it. So the entities, political entities, are free to solicit nominations in a public way and in a special vote way, but they may not delegate that authority. They have to vote on it.
Right.
Does your amendment accomplish that?
Pardon me?
I'm trying to figure out if your amendment
Well,
is...
the amendment is twofold. The first provision of the amendment was to, instead of appointed, to add or elected to it, because there are boards such as MEAG and MGAG where the city will actually elect somebody, not appoint somebody. And so that was the first amendment, so to make it more flexible. And the second amendment was to make it clear by reiterating that it had to be by an official or officials that applied to both the state and to the local governments. There was a question in subcommittee as to whether it did that. And I would just point out that the reason that we say appoint or elect is that in some cases you've got appointments that are done by a vote of the city council or the county commission or whatever it may be. But in some cases it may be that you as a commissioner get to appoint somebody to the recreation authority or whatever it is. And so it's clear, as long as it is an elected official doing it rather than an outside entity doing it, that, you know, whether it's elected or appointed, that it meets the criteria of the Supreme Court decision.
Thank you, that's very helpful.
Thank you. Any other questions? At this, who do I got there on 26? Chairman Fleming.
Thank you, Mr. Chairman. And Mr. Chairman, Chairman Powell and I, as he mentioned, and the author of the bill has mentioned, we had a good conversation in subcommittee by this. I was reading through some of the information I had on this. I know across the state sometimes grand juries appoint people to various boards. And would a grand jury be disqualified under this bill by appointing somebody to a position which constituted a board authority, commission, or similar entities? They're not elected.
Representative Oliver, did you have an answer to that, or because I saw you light? If not, do you want to just hold off?
Constitutionally, and I'm not sure how many school boards are still appointed by grand juries, but they were originally in Georgia, appointed by grand juries. That's how Jimmy Carter got on the school board of Sumter County. He was appointed by the grand jury.
If I may, Mr. Chairman, the example that I had goes back to the discussion we had in subcommittee about MEAG. And I had tried to do some research on this, and so I could help Representative Jones try to perfect his bill. And I thought through that after the subcommittee. The example here is the Crisp County Power Commission has a seven-member commission. This is a MEAG entity. 3 of which are appointed, 3 of which are county commissioners, and 4 are appointed by the grand jury. So the Crisp County Power Board has 4 members appointed by the grand jury.
Mr. Chair. Okay.
Please.
Mr. Chair, as I understand it, and reading rulings going back even Mag versus Rogers, if it's not in the Constitution, in Georgia's Constitution, like the state bar was, where they made appointment to the JQC. If it's not in the Constitution, regardless of where that board is, they cannot do it. So I guess, you know, in the case of a grand jury, if it's in Georgia's Constitution, they can. If it's not, I know across the state there are boards being reconstituted because they didn't meet the constitutional requirements, and so
your argument would be that in the case cited by the chairman of the judiciary, your argument would be that because no one really has challenged that, if it's not in the Constitution, once it's challenged, it would be in the same circumstances that for the reason you brought this bill.
yes.
Thank you. Chairman Powell.
Representative Jones may be accurate, but I don't know, and I don't think anybody in this room knows. I would make a motion to table the bill till we can find out the answer, because I certainly do not want to pass a law that is going to change the way that grand juries do business and a lot of our local governments do business without knowing that we have to do it that way.
And I'm not looking to oversimplify, because I default to the learned attorneys here in this committee. Is it as simple? Can it be amended to include all, to do what we're doing, and grand juries?
No, because if the Supreme Court has said you constitutionally can't delegate this authority to somebody else, then we can't add grand juries to it. But if the Supreme Court does not include the things that grand juries do, then we just need to make sure that we aren't making things tighter than they need to be. That's why I say we need to find out, and that's why I would suggest we table it.
And Mr. Chairman, if I may, if I'm allowed, I apologize to Representative Jones in subcommittee for overlooking that one point that I should have made then instead of full committee, and I'll be happy to try to work with him to try to find the answer to.
You mean one of those
Chairman Powell's
categories
question.
if we try to do all the work in sub?
Yes, sir.
All right. Representative Jones?
Mr. Chair, I certainly appreciate the members' consideration of this legislation, and we want to do something that we all feel comfortable with. If we are going to look for an answer, where's this answer going to be coming from? Are we going to seek legal counsel, or okay? And so, if they don't, I'll give you all a copy of what the 2 rulings are. But if you were to read through it, it kind of does go into detail pretty much about if it's not in the Constitution, you cannot do it. But you can amend the Constitution, so I'll leave that there.
I'll tell you what I'm going to do. Let's show a little chairman's discretion here. And Representative Jones, I'm going to allow, because we've got another bill to hear, we'll come back and revisit that particular issue, because I am inclined to table it unless y'all can get together and see that there's a different path. So if at this particular point, if Representative Jones and Chairman Powell or Chairman Fleming sees another way and there's an interpretation, because we don't know. We're going to defer to y'all. But and with the help of Legislative Council, if you see something else that we're missing, then let's go ahead and do that. Is that satisfactory to you?
Yes, sir.
And if not, we're going to move to table it.
Okay.
House bill, the committee now calls House Bill 73, Representative Mark Morris. And Chairman Fleming or Powell, he's going to get an opportunity to make his case. If not, then we'll move to table. Thank you. Representative Morris, House Bill 73, is that right?
That's correct, Mr. Chairman. Thank you. House Bill 73 seeks
Excuse me. Recommendation out of the committee, Chairman Powell.
Was do pass.
Thank you. Please proceed.
House Bill 73 seeks to revise the prohibition against persons that are engaged in the bail bondsman business from serving in certain elected positions. Currently, the only position that someone that's engaged in the bail bondsman business can be elected to is a local school board. There are certain reasons why we obviously would perhaps not want someone with such a conflict of interest to serve perhaps on the county commission, where they could affect the sheriff's budgets, city commission or city councils where they could affect the city police departments, judges, law enforcement. But I could see no case that would present this class of people from serving at state level offices, such as the House and the Senate, and that's what this bill currently seeks to do, is to remove those barriers of service.
All right. Any questions from members of the committee? Representative Oliver.
I'm thinking about this bill in terms of other conflicts where the courts have ruled there's a conflict with a member of General Assembly and business with a state entity. And particularly there's a couple of different cases on lawyers who are members of General Assembly not being able to or having certain restrictions on suing the state. I'm trying to figure out whether that's in this category in some way. Secondly, you obviously have a local school board member that wants to go in the bonding business. That's what paragraph A is that correct?
Well, the way the current law reads, that's the only position locally that they can serve in is the school board. So we're leaving the local rules in place, but simply opening up opportunities where they might serve, say, in the House or the Senate. So we're identifying what the local positions basically mean, everything but school board. And that's the way it's currently written now. And we're just identifying that the school board does not apply to other local elected officials, I believe is the term we use there. So they could still continue to serve at the school board level.
I'm just thinking about what other conflict of interest cases there are about General Assembly members and business of the state, other than the series of cases on lawyers, and I can't remember any, but there are some, I think.
Well, I'm sorry. You know, it's clear with the civilian legislature, we're going to have conflicts of interest. We have doctors, we have lawyers, we have teachers, we have auto dealers, insurance agents. We represent a cross mix of, I would say, the people of Georgia. This one, and in those cases, we have Rule 133, which allows us to identify what the conflicts are, and ask to be excused from those votes. As I mentioned in the subcommittee, I know of at least 2 cases this year within my business. I'm in the staffing business that I will probably ask to be excused under Rule 133. I think we should trust this class of people the same as we do others and not discriminate against them in terms of service and expect them to adhere to the same rules that everyone else does.
Chairman Allen Powell.
Thank you, Mr. Chairman. Gentlemen, well, I'm a little bit familiar with this since I'm the one that put the school boards in there years ago for bail bonding. But as I look to see what you're wanting to do for legislators or state officials, the reason that there's always been a policy never to allow a local elected official, as was mentioned a while ago, that a county commissioner or a city council member may have undue influence on the law enforcement personnel. Do you not think that might also transfer up? I know once upon a time being a state representative or a state senator carried a lot more juice than it does today. But at the same time, to do that, would these people not also have a certain level of influence over law enforcement to say get a little bit better treatment for a customer or a client that they're posting the bond for?
Well, as you know, Mr. Chairman, the members of the House of Representatives are of impeccable character. That was meant as a joke, but I don't
Wow.
think that.
I'm sorry.
I'm sorry.
Yeah.
Oh, I'm sorry.
I'm sorry.
Well,
bad time.
Order,
I thought
Alan.
you-
Alan.
I'm sorry. I
Chairman
thought you were
Powell.
talking about a member of Congress.
Chairman Powell, I'm never going to blame it on you not being able to accept a good joke. There's a huge delivery problem. Just huge.
Okay.
Nobody.
I'm outside my coverage area. I'm sorry. The question was that could they affect local? They could affect law enforcement. I would like to believe that this body as a whole would correct any action of one individual.
Other Chairman Powell.
Chairman Fleming and I evidently do our best work after subcommittee.
Wow. Here we go.
But we were just brainstorming about why this prohibition might have been in the law to begin with. And I think everybody understood that because school boards don't do executive functions like other local governments do, that part of the reason is that you didn't want somebody on a city council telling the police chief, for instance, to give a preference. But another reason, which brings into the state prohibition, is that when a bail bondsman signs a bond, he is guaranteeing to the governor of the state of Georgia that person will be there or that money will be forfeited. And so it very well may be that was the reason for the prohibition before. And so, like we said with Representative Jones, I would want to know the answer to that before we proceeded with it. So I'm going to make a motion again to table. Because we did not consider that at all as far as a bail bondsman does sign a commitment to the governor of the state of Georgia.
Wow. Representative 16.
Thank you, Mr. Chair. I was also thinking back to this being a statute that's been in existence for 30 years. Are you aware of any other states that have similar prohibitions? And if there are any, have they been subsequently repealed or changed?
No, ma'am. Unfortunately, I'm not aware.
Thank you.
Now, did I hear it's your turn?
Oh, Lord.
All right. 26, Chairman Fleming.
Mr. Chairman, Chairman Powell and I were just discussing his proposed motion to table, and as you did with Representative Jones's bill, the chair obviously has the authority to hold the bill and let us get an answer, and then we don't have to have a motion to bring it off the table, but that would be the chairman's choice, I'm sure.
So let me just make sure I'm trying to figure out my posture. I'm going to hold this to get back to the previous hold based on work that was done in sub that wasn't done.
I just don't want any of my bills sent to Chairman Powell's subcommittee because I want to get out the committee.
Vernon, is that posture about right? Yes, sir. All right, so we're going to, so Chairman Fleming. we're looking to potentially hold this to see if we get an answer?
And I don't think we're gonna get that one right here unless
Okay.
legislative council's able to do
So
that.
then
It
we
might
need
have
a
to be for.
then the
another-
chair would prefer a motion to table.
I second Chairman Powell's motion table.
All right. We got a motion and a second. Any discussion? All those in favor of tabling House Bill 73 signify by saying aye.
Aye.
Those who want to keep this going on, speak now, and I want to see who you are with a hand. We've got a table. Thank you.
Mr. Chairman.
And I would say, if I may, Mr. Chairman, Representative Morris, we'll help you try to find the answer to this question if you just get with us. But I think it's something Ledge Council can look up for you. And I think once we get it answered, we could act on your bill.
Thank you.
Yes, sir. Thank you.
All right, I love the lawyers. I'm on a legislative council where I don't butcher what I was just told by my vice chair. Can you weigh in on the thoughts as we bring in Representative Jones back up on what House bill was this? 24. You had thoughts, I think, legislative council. I asked briefly, Chairman Powell and Chairman Fleming, Legislative Council, I think, had something that they were thinking of at the end, so I'm going to let him a chance to explain his thought process, and then let y'all pretend like this is judiciary minor. Is that right, Representative Aller? Getting close to it? So tell us your thoughts as you shared them with the Vice Chair.
Yes, sir. Reading over the Supreme Court case that the center of this proposed legislation, what the Supreme Court said is that governmental appointment authorities can't be given to, quote, private entities. Grand juries are not private entities. They are actually creations of state law. Each county has grand juries, so the grand jury is a governmental body which apparently would not fall under the Supreme Court.
I'm sorry. Can everybody hear him? I might want to, you're good? I might want to put you at the mic. Yeah.
I didn't mean to do this to you, Stuart.
You better watch him. Go ahead.
What the Supreme Court said in the relevant case that brought this apparently matter forward was that appointment authority can't be given to private entities. The grand juries are not private entities. Each county has a grand jury. It's a governmental body. It has governmental powers. So it apparently probably would not fall under the Supreme Court's holding in the case about the DeKalb County Ethics Board, since that really only dealt with appointment powers given to private entities.
Does anybody have any questions of our legislative council in regards to that? Who do we? Yes. Representative Jones.
Thank you, Mr. Chairman. Can you articulate to the chair and the committee your recommendation then?
One way to address maybe the concerns that have risen is at the end of the proposed legislation add or grand juries. So the appointment authority would be with elected officials at the state or local level.
Chairman Powell, did you hear the recommendation at the end, which is to add or grand juries? I did. I was looking for the bills. And I want y'all to know that, and this has nothing to do with him being the chairman of rules. We get it out of here, you know, we just want to make sure it's fixed where it doesn't get sent down to us.
Yeah.
You think that fixes it? All right, so the fix would be, one more time, please.
Just at the end of the current sentence to add or grand juries.
That's on House Bill 24. Representative Oliver. I know your light's not on, but you're good. All right. At this point, any questions from members of the committee? Do you understand what we're doing on 24, adding or grand juries at the end of line 14, which is basically be the end of it, or grand juries? Any questions on that? All right. Representative Jones, is that your understanding?
Yes, sir. And I thank the committee for their recommendation.
At this time, then, the chair will introduce a recommendation.
Would it be a motion due pass by committee substitute?
Yes.
Okay, so motion due pass via committee substitute.
Yeah, let's take the amendment first.
Take the amendment first.
No, we're saying as substitute, amended. We never took it off the table. Right. Okay, I will entertain a motion to pass.
Motion due pass.
Got a motion to pass. Second, got a second. Any discussion? This is the appropriate time. What he said, which is, or grand juries. Do I hear a second? Any further discussion? Is that a yeah? Representative Brunel? It is.
Oh, okay. I was just questioning if, I understand the or grand juries, but if it should go after appointed or, and then grand juries? I mean, I always look at things according to power or position. And I was just wondering if it should go somewhere in between there as opposed to at the end.
I'm looking at and getting the thumbs up of the grant at the end. All right, we've got them. No, I get it. All right. Further discussion. Yes, Representative Jones.
Mr. Chair, I recognize the representative's comment, but I think for simplicity and ease of reading, I think the qualifiers before political subdivision make it clear that that is in fact a qualification against the political subdivision, and putting it at the end, I think, makes it clearer.
I'm always a fan of clearer. All right, we've got a motion and a second to accept House Bill 24 as amended. All those in favor, please signify by saying aye. Aye. Those opposed, like sign. Ayes clearly have it. Thank you, Representative Jones. All right,
Thank you, Mr. Chair, members of the committee.
I think that's it. We've got work that we're doing on two bills then that was in sub. Is that right, Mr. Chairman? House Bill 15 and then House Bill 73. Representative Powell, Chairman Powell.
Yeah, House Bill 15, we are waiting for some comments from the Housing Authority people. They were not represented at the hearing today. And so we just had a hearing only. And on House Bill 73, we're going to try to determine if the fact that somebody signs as a bail bondsman that guarantees to the state of Georgia and to the governor, and it was also brought up by Shaw Blackman, that you got to be concerned about the fact, since you are bound to the governor and the state of Georgia, does that bring an issue with the oath of office that you've got no monies owed to the state? So anyway, we need some things answered about that one for.
Very good. Any other discussion from members of the committee? If not, we're adjourned.